All right, good morning, ladies and gentlemen. Thanks for joining our 11th Forensic Friday webinar on challenges in presenting digital evidence in court. And to talk on this particular topic, we have a guest speaker. So before I introduce today's guest speaker to all of you, or we start our session, I will quickly share some ground rules of this webinar for the smooth functioning of this particular event. So quickly, I'll be going through some ground rule for this particular webinar, which I'm requesting all of you to follow. So first, please make sure that your mic is muted during the webinar and your cameras are switched off before continuing this webinar or before going through this webinar. This is required in order to just to make this webinar smoothly. And towards the end of this session, we will be clicking a group picture, and at that particular time, I'll be requesting or informing all of you to turn on your cameras. Till then, please turn off your camera. And all the interested participants will be receiving a certificate of attendance. And for that, you all need to fill a certificate form, or there will be a form, certificate form. So you need to fill that form, and the link for that particular certificate form will be provided in the chat box during or at the end of this webinar session. And we will be informing you all for that as well. Okay. For your questions related to this webinar session, you can put all your questions forward. We will try to answer them at the end of this webinar session. And if time runs out, we will make note of all the queries and we'll get back to each of you as soon as possible. So I can make it sure that no question of yours will be unanswered. So before I continue any further, let me share a little introduction of myself and about our company and about our owner as well. So I'm Subhashini Singh, and I'm a forensic solution consultant at ForensicsGuru.com. All right, so here are a few details about Mr. Samir Dutt, our company's founder, and he is widely recognized as the father of the Indian and South Asian digital forensics market. Since 1999, he is the CEO and founder of ForensicsGuru. He founded ForensicsGuru at a time when very less people were aware about forensics. Very less people were knowledgeable about this particular domain. So for over 30 years, he has worked in the United States, the United Kingdom, and India. He is the president of the Digital Investigators Association and an alumni of NIT Rourkela, IIT Kanpur, and IIFT Delhi. He is also a member of the Indian Police Foundation. As a fellow person, he has spoken at the National Police Academy, the CBI Academy, the NICFS Delhi, and in a number of other police institutions. He is also a TEDx speaker and the author of the best-selling book on learning network forensics. All right, so a brief overview of our company. So our company was set up in 1999. So we are the industry's oldest computer forensics and digital investigations organization. We are headquartered in New Delhi, and our digital forensics lab is in Faridabad. So this particular lab is the most up-to-date instruments or technologies from around the world are available in this lab of ours in Faridabad. So we have other branches as well in Jaipur, Bangalore, Guwahati as well. We have ISO 9001 and ISO 27001 certifications as well. All right, moving forward, we have been functioning in this industry for a long time, and we have accomplished a lot of goals. In actuality, our Honorable Prime Minister Sri Narendra Modi ji is quite interested in digital forensics tools and technologies. So he is a great supporter of this industry. In the pictures which you can see right now at your screen, you can see that several other dignitaries were also present to view our tools and technology. At one of the events, you may also see me in one of the picture with the Defense Minister of India, Shri Rajnath Singh, who is actually appreciating, praising our products, our tools and technology. All right, so among several other things, we have received several honors, testimonials, and awards, etc. We are a NESCOM Immersed 50 company, and we are the only company in this particular industry which is a NESCOM Immersed 50 company. I mean, we are well known. Okay, so we have a significant number of happy customers all around the world who have expressed their views about us very warmly, very strongly, very positively. So here are a few thank you notes or appreciation letter from these happy customers of ours. So this is the very first appreciation letter which you can see right now at my screen is that this letter, this very first gratitude letter we received from UNDP after finishing a training session for them. So we actually did a training session for them, and for that excellent training session performed by us, we just got this letter of appreciation from UNDP. Okay, so the next, the Indian Army gave us another letter of gratitude. So the Indian Army was looking into a particular challenging problem involving targeted Chinese malware. So we basically helped Indian Army in their investigation or in their malware investigation. So for that, we got the appreciation letter from the Indian Army. The next appreciation letter we got from the Delhi Police Force, and Delhi Police Force had also given this letter of appreciation for actually, we actually assisted or helped Delhi Police in solving a high-profile kidnapping case. And not only that, we also helped Delhi Police in retrieving over 1 crore 38 lakhs from the criminals, so which is a big thing. And one more appreciation letter we got from the Mangaluru Police. So what we exactly did for Mangaluru Police, we just did a number plate enhancement. So we enhanced a number plate of a vehicle which was used by a criminal, and we successfully enhanced that number plate, and Mangaluru Police successfully caught that criminal. So yes, we got this appreciation letter from Mangaluru Police very recently. All right, so we have an immense number of satisfied customers since we serve people from all different backgrounds, so or all different categories. So if I talk about national security area, all the 2 letters, 3 letters, and 4 letters agencies are our customers. In the defense zone, the Army, Navy, and Air Force all are our happy customers. All the state police forces and most of the union territory police forces are also our customers. Not only this, we also work with the private sector. All the big 4 companies are our clients. You must have heard about companies KPMG, Deloitte, PwC, Ernst & Young. They all are our happy customers. Other companies like Vodafone, IBM, they are also our clients. In the government sector, different organizations such as MHA, CERT India, SEBI, etc. They are our true and happy customers. Okay, so we have set up a number of digital forensic labs all across the country. As a result, a considerable number of CCPWC laboratories have been recently developed or set up by us. So here I have few pictures from these well-equipped digital forensics labs to share. So these labs actually, we have set up these labs in Jaipur, Chandigarh, Sikkim, Gangtok, Shillong, Daman, and Assam. So these are few pictures from all these sophisticated labs. All right, so with all these, I'm so pleased to be with you today and to have the chance to introduce our guest speaker for today's session, Mr. Nishid Dixit. So he is an advocate and a cyber law consultant for more than 2 decades and is a true standout in this particular field. Mr. Dixit has been versatile in handling civil cases and criminal matters as well, including cyber law, cyber crime, telecommunication laws, corporate and economic offenses, electricity laws, media and advertising laws, intellectual property right laws, real estate and banking laws. Not only this, he has been remarkable in advising top banks and corporations in legal matters. Mr. Nishid has been leading serious cases pertaining to the data theft, cyber defamation, social media crimes, banking frauds, ransomware attacks, and many more. Besides this, he has professional membership in Supreme Court Bar Association in New Delhi, Rajasthan High Court Bar Association in Jaipur, and Bar Council of Rajasthan in Jodhpur. He is also a very fascinating person, and we all are here for today. We all are here for a great learning experience from him. So with this, I would hand over this session to Mr. Dixit. Over to you, sir.
Thank you, ma'am. Thank you, Forensic Guru, and thank you all participants for joining today's session on digital evidence and admissibility challenges. I hope I am clearly audible and my screen is visible.
Absolutely clearly audible.
Thank you. So, welcome to a very challenging field, evidence part to prove before the courts. So that's a very important part. What about the evidence, whether it has been proved, not proved, disproved? So we will cover today's session in 4 parts. You can say like electronic evidence, what is evidence and what is electronic evidence? What is the difference between conventional crimes evidence and cybercrime evidence in the sense you can say. Then case studies, we will discuss some case studies where there was faulty investigation by investigating officers, and there was one of very important case study I will discuss where there was challenges faced by the forensic examiner, and his forensic report which he produced before the court, he submitted before the court, was not allowed, means you can say rejected by honorable court. So we will discuss at length that case study. And lastly, the judicial approach pertaining to electronic evidence, what type of cases we are handling and what type of judgments have been passed by honorable courts pertaining to emails and WhatsApp chats and other things. So I start with the evidence part. What is the definition of evidence? Yes, we all are aware about the evidence part because mostly people are from law enforcement agencies and enforcement agencies. So evidence means and includes all statements with the court permit or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. So we can provide our oral evidence, like eyewitnesses are there. All documents, including electronic records produced for the inspection of the court, such documents are called documentary evidence. So when IT Act was enacted in 2000, so Indian Evidence Act was also amended. So electronic records were incorporated in the all documents word, means Section 3 Evidence Act was amended, and all documents, including electronic records was inserted. That's a very important part. What is electronic record? Practically, yes, the information which has been stored. Suppose I prepared this PPT. It is firstly stored in my system, or if I have sent to Samir sir, or he has received through email. So whether it has been sent from which system or the system, the addressee has received the system, that PPT that is stored, sent, and received in electronic form is known as electronic record. So that's a very important part. Who is the originator? Who is the addressee? What intermediary we have used? What system has been used? So what computer has been used? What computer resource has been used? Means database I have sent to Samir sir. And what intermediary role? Means what is the role of intermediary? What communication in network I have used? My Wi-Fi. And the person who has received this content is using the internet. So that is very important pertaining to any investigation. That is CDR and IPDR part. So that is known as electronic record. So as far as the definition is concerned, so as per amended provision Section 3(2) of Evidence Act, electronic record is documents. All documents, including electronic records produced for the inspection of the court, such documents are called documentary evidence. And what about the IT Act definition? That means data record or data generated, image or sound stored received or sent in an electronic form, or microfilm or computer generated microfiche. So that's a very important definition under 2T of IT Act, and very important definition in section 79A explanation part. So that's a very important basic definition under section 79 explanation part, that is electronic form of evidence. Means any information of probative value that is either stored or transmitted in the electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. So I will cover up section 79A of IT Act, read with section 45A of Indian Evidence Act very carefully, very important part, because forensic labs must be careful about these things. The court can ask for expert opinion from the labs which have been notified by the MIT, Ministry of Electronics Information Technology, under section 79A. So we will cover this section also. Now, very important part, what about the authentication of electronic record? Suppose I have sent a content to Samir sir. So what about the authenticity of electronic record, whether it is maintained, integrity has been maintained? So how to check the integrity? So if we have taken the we are sending this laptop to forensic examinations, what about the integrity? So that's a very important part, that is the hash function and hash value. So where it is defined, the authentication of electronic record shall be affected by the use of asymmetric crypto system and hash function, which envelop and transform the initial electronic record into another electronic record. So hash function is mandatory as far as IT Act is concerned, as far as electronic record is concerned, as far as authenticity of electronic record is concerned. So a process used to confirm the identity of a person or to prove the integrity of a specific information. Message authentication involves determining its source and verifying that it has not been modified or replaced in transit, like man in the middle attack, like business email communication scam attack. We have seen so many cases. I'm handling so many cases pertaining to business email communication attacks. So yes, they changed the in between, they changed the bank details and the money was transferred to another bank. So that's a very important part. So recently, and in 2015, now we are using the digital signature and entity rules 2015. The cryptography hash function is, that is SHA, secured hash algorithm 2. That's a very important part. And second part is very important. We have covered the electronic record, we have covered the electronic evidence, section 3, like document, then electronic record, then authentication of electronic record. The most important part is the preservation, retention, and the primary preservation of electronic record. That's a very important. So if we are producing any electronic evidence before the court, so it must be subsequent accessible and it must be preserved in the same format. So that's a very important, that is section 7 of ITA. The information contained therein remains accessible so as to be usable for a subsequent reference. That covers section 4 part also. The electronic record is retained in the format in which it was originally generated. So it emphasizes on the preservation of primary evidence also. So what about the metadata? Yes, we have very important part in metadata in section 7, the details which will facilitate the identification of the origin, destination, date and time of the dispatch or receipt of such electronic record are available in the electronic record. So that's a very important part to prove before the court. Metadata is very important. We will discuss one very important case study of Madhya Pradesh High Court, where by way of that producing that metadata records, the accused got the bail. So that's a very important part. As far as 67C is concerned, preservation and retention of information by intermediaries. So central government may notify in gazette notifications to intermediaries to preserve electronic record for the some time limit, like IPDR, CDR 2 years, like matrimonial websites they have to preserve for 1 year, like cyber cafe rules they have to preserve one year database. So that's a very important part. So that's a very important thing, that they have to preserve, retain in the same format. They have to comply with the 67C guide notifications of the central government. If they fail to comply, they are liable for 3 years. It's a cognizable and bailable offense. Most important part is the investigation. So once there is a cognizable offense, a fire has been registered, the first responder reaches to scene of crime. The most important part is the identification of evidence, or it can be electronic evidence. So that's a very important part. First part is the identification, then the collection. So he has to comply with the complete SOP of identification. Then he has to comply with the collection procedure, then preservation, then transportation, and the most important part is the analysis by forensic examiner. And he has to take the pre-acquisition hash value, post-acquisition hash value, and the most important part is the post-forensic hash value. That's a very important part. And most important part is the chain of custody they have to maintain. So what is the difference between conventional crime evidence and the electronic crimes? You can say the way there is a electronic ICT is involved, information communication technology is involved. So yes, the person is entering into one's place, house trespass, you can say. So yes, their fingerprint impression, or the knife or gun they have, or it includes also electronic evidence like CCTV footage or eyewitness. Some guard has seen or some neighbor has seen that somebody has jumped into the garden part and entered into a broken the that window. And the most important part, the intrusion. The most important part, the internet intrusion, like internet trespass. So what about the evidence part? Somebody has hacked your system. So what about the IP address, which system he has been using, what system has been targeted? Yeah, please. Any questions, sir?
I guess no, sir. You please continue.
Okay. Somebody is talking means okay. So in this system, what type of evidence we have? So the most important part again is the IP address, the MAC address, the IMI number which he is using, the system which has been targeted. Again, we have to confiscate the victim system also. If there is any malware downloaded by that victim, again we have to get it the forensic examination. So mobile laptop is the primary source of evidence. We have to confiscate, get it forensically examined. That's the most important part. The most important thing is like spoofing. Earlier in the, like we have seen so many telephone manipulation at the time when we were using the landline phones. Now we have the spoofing techniques available. People are using spoofing techniques to call, to send messages, to send phishing emails, you can say, like business email communication scam also. So what type of email they have sent, what type of malware they have sent by way of that mobile, the system has been compromised. So we have to be very careful regarding investigation of these type of cases as far as electronic evidence is concerned. Now, extortion. Now we have very important case study like extortion. Somebody has called by way of using the WhatsApp video call. So he has called me and he has recorded my content, the conduct which I have conducted. So that's a very important part. The original primary evidence is my phone and that accused phone. So I have to give that phone because I have received that extortion, that content to me by that. I am the addressee of that content that originator has sent to me. So that's a most important piece of evidence which I am having as a victim. So that's a very important as far as law enforcement agencies are concerned. They should confiscate my phone and they have to send the forensic examinations. That's a very important part because the primary evidence is with my phone. And the most important is the lack of understanding of the sections of IT Act also, though it clearly attracts section 66E of IT Act and other part of obscene content or 384 extortion part also. That's a very important part pertaining to evidence part. And most important part is the internet fraud, like SIM sampling fraud. So in very important case we are handling where the company is having the CUG connection. And what happened in this case, criminals send an spoofing email to telecom company that kindly deactivate these two mobile numbers, and they attach the some like identification details and kindly provide new SIM to these persons. So that company entertained that spoofing email and they deactivated that mobile numbers, and the criminals got the two SIM numbers, and they afterwards, because the OTP was sent to new SIM number, and they siphoned off 60 lakh rupees. So that's a very important part. Who is sending by way of spoofing techniques, whether we are competent enough to identify these type of spoofing mails or not. So these companies, these intermediaries has to provide these type of electronic evidence by way of providing that screenshot, by way of providing 65B certificate. That's an important part, because how to prove these type of secondary output evidences before the court. So yes, they have to preserve the primary evidence, that the email they have received from the criminals, that spoofing email, the message path, you can say the header details you have to prove before the court, the header details, message path in the electronic form and the paper form, the printout form in A4 size, and they have to send by converting into PDF file, and then save means transport into a memory card or pen drive before the court. That's a very important part. Now, that's the most important thing is the identity theft. Yes, we have so many cases regarding the usage of biometrics or usage of voice cloning. We have so many cases worldwide also where voice has been cloned. We have so many softwares available where voice has been cloned, and misuse of the voice has been used. Like in Germany also, the managing director's voice was cloned, and they got the money transferred from one bank to another bank by way of using that is spoofing techniques and the voice cloning that technique also. And most important part is that child pornography evidence is very important, like tip line, like FBI, like agencies. They are receiving so many informations like IP address, like MAC address, like other details, that mobile numbers, the IMI numbers, that this mobile or device has been used to download, upload a child pornographic content. But most important part, to prove before the court, you need the 65B certificate, you need that confiscation of the primary mobile phone or laptop the criminal, the accused was using at the time. So if we means receive the report after 2 years and we are investigating after 2 years, we don't have the original mobile phone or laptop of the accused. So, obviously this case will be diluted before the court, because we don't have the original electronic evidence by that the accused was using at that time. That's a very important part. So firstly, we have to confiscate the primary evidence, that is mobile phone or laptop. That's a very important. Get it forensically examined, no malkhana, get court permission, that is compliance of 102 CRPC is mandatory. So be careful about the compliance of, once you seize anything, you have to inform the concerned magistrate. That is the word is the forthwith. Immediately you have to inform the concerned magistrate. Get that their consent then means order, and then send to FSL. That's a very important part regarding child exploitation also, and other part of evidence also. Now we have so many electronic evidence available on desktop computers, laptop computers, servers, USB devices. In one of the cases, what happened, the laptop was confiscated from the scene of crime, and that doesn't have any means. You can say there is no inbuilt camera in that system, and it was produced before the court. And prosecution story was that this laptop was used to capture the private area part. Defense objected that this laptop is not having the camera. So again, there was no answer by the prosecution. So if it has been sent to the forensic lab, they were able to get the information about the USB device viewer. So we have CD DVDs like mobile phones. So always remember this type of, because I'm presenting so many cases as a defense lawyer, and the most important part is the means once you don't confiscate the primary evidence, only you have taken the screenshot with 65B. So at the stage we will definitely we will object where is the primary evidence and where there is any forensic report of examination of that primary evidence or not. So merely screenshots are really dilute your case. So always confiscate primary evidence, counsel the victim or complainant, get primary evidence, get it forensically examined. The most important part, digital video recorder. I will discuss very important case study of one sting operation and the ACB case, that Anti-Corruption Bureau case. So digital video recorders, digital audio recorders, these are very important part in as far as the electronic evidence is concerned, to produce before the court and to get the forensic examination also. So yes, what about the file structure? Yes, we have to be careful about the understanding of the file structures. What about the files? Like criminals are very they are intelligent enough to save these type of files in other systems, you can say. And most important part, the type of evidence we are generating, like memory, the cloud, like automotive, like satellite, like drones and mobiles, SCADA, and then IoT, then GPS networks, host IoT devices. We have IOFT, Internet of Flying Things. We have Internet of Machine things, like Internet of Military things. You have Internet of medical devices things, you can say. So we have very important evidences available in like cyberspace, you can say. So we have to be very careful as far as confiscation is concerned, as far as forensic evidence is concerned. So the major phases of investigation by investigating officer is to ascertain and record the facts concerning the commission of crime, to identify criminal and his compliance, if any, to arrest and apprehend criminals, to secure, preserve, and evaluate evidence. That's the most important part. So to put evidence in court in a legal and presentable manner. So what type of evidence we have collected? The most important part is the maintenance of the chain of custody, the digital evidence collection form. We have to be careful pertaining to handling of the electronic evidence, and carefully we have to send it directly to like FSL by way of getting the permission from the honorable concerned court. So most important part, what type of complaint we have received, whether we are able to understand the crime which have been committed, because that's a very important part. What type of the law it attracts, what type of information we have to gather from intermediaries, that is also electronic evidence. whether it has been supported by 65B certificate, whether it has been accompanied with 65B certificate, whether we have notify them to preserve the primary evidence. If we are unable to produce primary evidence before the court, we have to be very careful. We have to notify the the person who is providing secondary electronic evidence. We have to notify that person to kindly preserve the primary evidence till the disposal of the case from honorable courts. That's about most important thing. We have to be careful. And most important part, they collect relevant information from intermediaries or the bank. If we are getting information, computer generated documents from bank, like bank statements, it must be accompanied with Section 2A certificate of Banker Book Evidence Act 1891. Then crime scene visit, okay, like in data theft cases or man in the middle attack or like ransomware attack, or corporate espionage cases. So yes, evidence identification, then collection, then preservation, then transport to FSL. What type of questions you can ask to FSL? I will discuss one very important case of CCTV footage also. Then request for analysis. So most important part, once you confiscated laptop, mobile, by way of honorable court's permission, send to that FSL, and always notify and request these FSL lab kindly provide image copy of that mobile or laptop with hash value. That's a most important part, because you have now the image copy. You can expedite your investigation by way of that hash, by way of that image copy. That's most important part, because FSL is under pressure. They will provide you information or FSL report after 2 years or 3 years. It depends upon the case-to-case basis. But if you have immediately the image copy with you, you can expedite your investigation by way of that sound evidence. You can say, you can file a charge sheet, and then after you can get the FSL report from submit the FSL report produced before the court by way of forensic examiner analysis. That's the most important part. So what about the interpretation? The report received from FSL, we have seen so many cases where charge sheet have been filed, but FSL has not been filed. FSL report has not been filed before the court for 5 years, 6 years. So obviously this will dilute your case, and obviously mostly chances of the acquittal of the accused. So reconstruct the case and prepare the charge sheet as far as concerned. So the most important part is the investigation of every case is 360 degree, because in one of the cases, what happened in Honorable High Court instructed DGP of that state to register a case against the investigating officer under Section 166A IPC, because he didn't confiscate the CCTV footage from the scene of crime. So that's the most important part, the judicial approach pertaining to these type of faulty investigation. That's the most important thing. We have to be careful. And most important part, what about the identification of electronic evidence, preservation, seizure, packaging, and like label, bagging, tagging? What about the seizure memo? That's very most important part. The witnesses, you have the interpretation of that report. We have to be very careful about the understanding of the FSL report of electronic evidence, because in so many cases we have seen the understanding of source code theft cases. I will discuss one very important case study also, like source code cases. So IO must be careful about these type of electronic evidence or these type of cases like corporate espionage, like source code theft, like data compromise cases. So these were very important aspects pertaining to investigation, and also to produce before the court. And cross-examination of IO is very important as far as these type of chain of custody is concerned. So who identified, who extracted, who collected, what about the label, bagging, tagging, what about the seizure memo, whether it has been captured in the by way of using audio video recorder or not, or who transported that electronic evidence to FSL, what about the forensic analysis, what about the pre-acquisition hash value, what about the post-acquisition hash value, what about the post-forensic hash value. So these are some important aspects which means you can say the defense can object before the court regarding digital evidence collection form, whether it has been maintained or not, the third part also which has been incorporated or not from the scene of crime, from the once he confiscated and once they are producing before the court by way of forensic analysis by FSL. So if we go through by the issues related to enforcement, yes, difficulty in detection of crimes because of the recently crimes like drive-by download, tailgating crimes, or other part of important aspects like ransomware attacks and the like Cosmos Bank attack also. So they are masking of identities, another very challenging part. Then the volume of data on the internet, intermediaries, as far as IT rules 2021, their compliances, they have to be complied with, because within 72 hours, they have to inform the first originator, Indian territorial originator, as far as 5 years or more than 5 years offense is concerned. The most important part is in cybercrime and other part of electronic evidence like KYC issues, like SIM swapping, like beneficiaries, who is the money mule, who is getting the money transferred in this account, like crypto and another part also. And the challenges pertaining to admissibility of electronic evidence, data protection is very important. The disclosure dilemma is very important. The company's database has been compromised. They have disclosed that we have been compromised. What about the issue? Because the customer data bank has been, the customer sensitive data information has been compromised, and it is now available in public domain. So that's an important part. And the most important thing is that jurisdiction part, means like mutual legal assistance treaty, like a letter of regulatory from honorable courts. So as an information, like as an investigating officer, we have to be very careful about these things, because timely, if you investigate these type of cases like mutual legal assistance treaty, where you require evidence from another country, like business email communication attack, like man in the middle attack. So in one of the cases, what happened, and as I was handling that case as a complaint advocate, my complainant he dispatched a product to a European client. That European client received that product, and he sent an email that I have received the consignment, you can raise your invoice. So my client sent an email with the attachment of the bill of Indian bank details, and it was intercepted by hackers. You can say it was a man in the middle attack. You can say business email communication attack. They altered the database. They changed the bank address by way of incorporating Bank of Australia. It was earlier the Delhi bank address, and they changed the bank details of Bank of Australia, and the mail was sent to the European client. The European client received that email, and by way of and he's transferred 1 crore 30 lakh rupees to Bank of Australia. Once the 91 CRPC notice sent to Bank of Australia, they replied, come through by mutual legal assistance treaty. So this is the major, you can say dead end, you can say, but you have to be careful. You must initiate mutual legal assistance treaty. So to get electronic evidence from or other part or other documents or other evidence from that country also. So that's the most important part. Preservation is very important. Send preservation notice by way of MLAT also. So that's the important part. These are some important hurdles, you can say, in by way of which the enforcement agencies are facing. So yes, Locard's principle, yes, by way of Cosmos bank attack and other type of anti-forensic tools they are using. Yes, they are challenging the Locard's principle now. It's a very dangerous attack, you can say, on the Cosmos bank, but yes, Maharashtra police did a commendable job. Now they have initiated the extradition treaty with like UAE. 3 persons have been nabbed in UAE. So the most important part, now criminals are able to wipe out digital footprints from scene of crime. So that's the most important part. Anti-forensic tools they are using, wiping softwares they are using. So again, they are using the sophisticated technology. Now they are capable to wipe out digital footprints from scene of crime. So very important case study I want to discuss with you, like in Bhopal, fake call centers. What happened? They received a tip from some person, and they raided a call center. It was a fake call center. So what happened in this case? They purchased the database from dark web. So another very important section we have in section IT Act, that is section 66B. So if somebody is dishonestly receiving or retaining any computer resource, what is computer resource as far as IT Act is concerned? Computer system, computer network, database. So if somebody is using, somebody is downloading, somebody is purchasing by way of Bitcoin or other any type of consideration, he's using that retaining or dishonestly receiving any computer resource from a stolen database. So we all are aware that on dark web, mostly compromised breach data is available. So what happened in two accused, they purchased the database of US citizens, 1 lakh US citizens, they purchased database from dark web, and they purchased the Magic Jack device. They learned the accent training of US citizens, and they were able to communicate with US citizens by way of using that Magic Jack device, and they siphoned off huge money. And most important part in this type of cases, the gathering of the information, which was a rental premise, seizure and forensic analysis, laptop, desktop, Magic Jack devices, and external devices, challenge to retrieve the data of victim from US transaction, because all victims are of US citizens. So by way of VC, virtual conferencing, within 2 years, heads off to honorable court also, because within 2 years, 8 accused were convicted under these sections. So most important part, the investigating officer was able to seize the ID and password of their virtual wallet. That's the most important part. And the FBI also cooperated, because mostly all victims are from US. So That's the most important, successful, you can say, case study where electronic evidence was captured, and they also seized the crypto wallet. They changed the ID password, you can say, private key. Now it's a code property, and that's a most important successful case study by Bhopal Cyber Cell. Now, most important part as far as means Indian judiciary or criminal justice system is concerned pertaining to Evidence Act, whether it is fact of issue or relevant fact. So the evidentiary value of an electronic record can be judged on these parameters, you can say. First is the admissibility or proof of electronic records, whether it is admissible or proof, whether it is genuine. That's the most important part. So it can be admissible, but what about the genuineness? What about the integrity of that, authenticity of that electronic record? So what about the exhibiting or playing the electronic record before the court? So if there is any CCTV sting operations, you have to play before the court, because it's like time machine. Court can visit the scene of crime by way of using that, by way of viewing that CCTV footage. So that's the most important part, and the most important part is in section 165 Indian Evidence Act Provision 1. Judgment must be passed based upon the facts declared by this act to the relevant and duly proved. So what we want to prove before the court? What about the prosecution? Prosecution has to prove the fact, means you can say that it's relevant fact, but it is duly proved. Can be relevant, but it is not proved by before the court that it is not admissible. The court will discard this type of evidence. So this is the most important part: the relevant fact and duly proved that before the court. So very important part, if we are producing the electronic evidence before the court, what about the metadata? That's the most important part. We have covered the section 7 of the IT Act also, where it has been clarified what is the metadata. The most important case study is the very important case where the applicant has filed his third bail application before Honorable High Court under section of 302. It was a murder case, 147, 148, and other sections. So Cyber Forensic Lab indicates that photograph submitted by the applicant was in support of his innocence on the basis of plea of LEB. From perusal of metadata of photograph, it is prima facie clear that the present applicant was present at Bakaspur village, that is a part of MP, on 2nd April 2019 at about 1:34 p.m. and time of incident is around 1:30 p.m. to 2 p.m. on the same day at village, that part. The distance of place of incident is around 60 kilometers, 70 kilometers from the place where the applicant was present at 1:34 p.m. Such distance can only be covered by the applicant is not less than 1 hour at least. Therefore, metadata of photo and report indicate that he was present at the time at a place 60 kilometers, 70 kilometers away from the place of incident, and no tampering has been made in photograph. So that has been clarified by the Cyber Forensic Lab. This is the case mainly in respect of digital forensic evidence, and metadata of any photograph is a big tool in the hands of forensic experts to reach to the truth about the exact nature of incident. Trial courts are expected to scrutinize the said scientific tool with care and deep study so that forensic examination of evidence can be done to its highest standards. Metadata can be here useful, especially in cases where plea of LEB is taken by the parties or accused, in particular that he was not present at the scene of crime. He was present with his family, you can say. So photo, metadata, details, and report of digital forensic experts should carry due certification as per Evidence Act and other relevant provisions. So that's a very important case study pertaining to metadata to prove before the court by way of forensic analysis, by way of the certification or other documents provided by the forensic lab. So the most important challenge is the electronic record, whether it is primary or whether it is secondary. So if you are adducing primary evidence of electronic record, there is no requirement of 65B certificate under Evidence Act. But if you are producing secondary electronic record, means you can see secondary evidence by way of electronic record of secondary evidence you are producing before the court, it must be accompanied with 65B certificate. So we have 4 judgments as far as 65B is concerned. First was the Parliament attack case, then Anwar versus Bashir, where Honorable Supreme Court clarified that 65B certificate, if you are reducing secondary electronic, means secondary evidence by way of electronic record, that you can say 65B is mandatory. Then after Shafi Mohammed, and recently in 14 July 2020, the Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Kurential and others. Very important. I request you to please go through by this judgment. That's the most important judgment as far as like judicial approach of Evidence Act is concerned. So in this case, Honorable Court clarified what is primary, what is secondary. So the information which is firstly stored. So that is the primary. Suppose this PPT is stored in my system. I made this PPT for today's session. So I have taken the secondary output by way of using pen drive. That is secondary evidence. So once I am taking the output from that primary evidence to my pen drive, that is secondary evidence. Honorable Court clarified in this judgment the stage. Honorable Court clarified that a charge sheet is the stage, but by way of if you are unable, means if you were unable to produce the 65B certificate during the charge sheet. So it depends upon the discretion of the trial court that they may allow or they may disallow. So it's my advice that always file 65B certificate at the filing once you are filing the charge sheet. It must be accompanied with 65B certificate, any secondary evidence. So for primary evidence, there is no requirement of 65B certificate. The Honorable Court has clarified where you are unable to produce the computer system network before the court. Then the mode to prove that electronic record, that is section 65B certificate. Once you have the primary mobile laptop, confiscate it, get it forensically examined. There is no requirement of 65B certificate. Then very important part, that is section 45A, read with section 79A Indian Evidence Act and Information Technology Act. So central government to notify examiner of electronic evidence, that is EEE. So the central government may, for the purpose of providing expert opinion on electronic form of evidence before any court or other authority specified by notification the official gazettes. So MIT has declared 10 forensic labs as EEE since 2017 that will take care of electronic form of evidence, that is means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, video, cell phones, digital fax machines. So what about 45A? 45A says opinion of examiner of electronic evidence. So when in a proceeding, the court has to form an opinion on any other matter relating to any information transmitted, stored in any electronic computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of the IT Act is a relevant fact. So during the proceeding, if there is any objection raised before the court, suppose you have confiscated one evidence, means laptop, and it has been produced before the court, and if there is any issue related that genuinity and defense has objected before the court, honorable court can seek an expert opinion under section 45A, read with 79A. So they will ask these labs. So we have 10 labs till today which have been notified by MIT under section 79 as a EEE. Certain in New Delhi, Himachal Pradesh, Dharamshala, Army Cyber Group. So it has been clarified that for computer media forensic, floppy disk and mobile devices, so you can visit MIT website. Then Army Cyber Group, then State Forensic Lab Bengaluru, CFSL Hyderabad, Director of Forensic Lab like Gandhinagar, Gujarat. Then SFIO Delhi, Forensic Science Laboratory Rohini. We have 5 labs in Delhi, you can say, Cyber Forensic Division, then Thiruvananthapuram, Kerala recently, and Cyber Forensic Lab, Air Force Cyber Group. So we have 5 labs in Delhi, and then Bengaluru, Kerala, Gujarat, Dharamshala, and CFSL Hyderabad. So we have 10 labs from which honorable court can seek an expert opinion from these type of labs which have been notified by MIT under section 79A. That's the most important part. Now I want to discuss some very important case studies where there was faulty investigation by law enforcement agencies. So there was a case where complainant came across a TV advertisement relating to job, marriage, etc. Complainant contacted on the given number for a job. When she went to the office, she was asked to drink water, and soon after consuming it, she felt dizzy and became unconscious. When she regained her consciousness, the accused told her that he has made MMS and has taken obscene photos. She was allegedly raped by the accused. That was a statement by the prosecutors or victim, you can say. So defective investigation, I was failed to bring the copy of CDR on record, not accompanied by 65B certificate. I may have failed to seize all mobile phones of the accused because 2 mobile phones were confiscated by the investigating officer in this case of the accused, and they were sent to FSL. So I did not acquire the telephonic recording between the prosecutors and accused, as FSL report shows that there was no obscene video or photo related to the incident in the mobile phone of the accused. So in this case, what happened, IO confiscated 2 mobile phones of the accused. They sent mobile phones to FSL, but FSL report clarifies that these mobile contents means mobiles contain the obscene content, but not relevant to prosecutrix. That's the most important part. So no examination, the most important means you can say blunder, you can say no examination was conducted on the mobile phone of the prosecutrix. That's the most important part. So it is my opinion also that kindly counsel the prosecutrix, get original mobile phone, primary evidence of the prosecutor's victim, get it forensically examined. That's the most important thing. So technical challenges, yes, non-using of scientific latest techniques like photography, videography, then non-collection of certificate under section 65B, non-seizure of those all mobile phones used in commission of the offense by IO. It might be possible that third phone they were using. What about the CDR or by way of IMI run, you can say, or by way of other type of like 27 information. So we were IO must have done these type of things to take the third phone. It might be possible. So non-collection and forensic analysis of the complainant's phone. That's the most important blunder you can say in this case. Another very important case, the mob lynching case. There was a mob lynching. So honorable court strongly objected at the time during the hearing that witnesses have verified it by examining the video clippings. Learned District Council was not in a position to tell us how and from whose device the video clippings were obtained. So mostly important part, like in Sanjay Rao Chauhan judgments, Honorable Supreme Court in 2015 clarified, source and authenticity are two cardinal principles. So here is also Honorable Court's concern was the who prepared the video. What is its source? Where is the original primary evidence? What about the authenticity of that this footage, you can say. So this is the most important part, strong judicial approach at the time before the court, that what is the source, who recorded the content, what about the authenticity. So now in this case, the Honorable Court instructed the Superintendent of Police to delegate this to appoint any officer who is well conversant with collection of digital evidence. And in this case, as far as the information is concerned, they have confiscated the 5 original mobile phones and they have sent to forensic lab. Now this case is very strong. So this is the most important part. As a law enforcement agency, kindly confiscate primary mobile phone, primary evidence, and get it forensically examined. That's the most important part. In this case, what happened? There was again a rape case. Okay, now the outcome is the acquittal of the accused. So non-seizure of primary evidence. The police could not seize the mobile phone used by the victim. Some inputs of vulgar messages were sent by the accused. In this case, non-preservation of primary evidence. Mobile phone was handed over to a scrap dealer. So in this case, IO did not confiscate the primary evidence from the victim, and afterwards the victim sold out that phone to scrap dealer. IO questioned the scrap dealer but could not recover the phone. So again, now it's zero evidence, you can say. Non-collection of information from mobile companies. Mobile companies replied that the required information is not available. Was timeline. Earlier it was only 1 year. You cannot ask after 2 or 3 years, and you provide IP address. No forensic analysis. The laptop was not subjected to scientific analysis, and it is claimed that the hard disk got damaged. So again, laptop was also not confiscated, and afterward the laptop was sent to service provider, and service provider sent that the hard disk is damaged. So in this important case, IO failed to confiscate original mobile phone and original laptop. That's the most important part. So digital evidence which could have corroborated testimony of prosecutors was not produced before honorable courts. So in this case, the laptop was serviced almost 3 months after the registration of the FIR. This is the most important part. So the laptop was serviced almost 3 months after the registration of FIR. So immediately the IO must have confiscated the primary evidence from the prosecutors or complainant or victim, you can say. So in this case, again, the result is the acquittal. In very important case in Virendra Khanna versus State of Karnataka, where the court has clarified, then court has you can say detail out the process regarding if accused is not providing like password of mobile phone, or is not disclosing email ID password. So what enforcement agency can do? So, but in court has clarified other things also. Right to privacy of accused data pertaining to data. Yes, IO has no right to disclose the private data seized from the smartphones or electronic gadgets of an accused to a third party without the written permission of the consent courts. Data retrieved during the course of investigating officer would not amount to violation of right to privacy. An accused cannot be constrained to disclose the password of his gadgets or accounts through a mere order of a trial court to cooperate with the investigations. Court cannot suo motu in order to accuse to disclose his password, because court is not a part of investigation. But honorable court in this case laid down the procedure for examining smartphones or email accounts. Suppose accused is not willing to provide password. What IO can do? IO can file an application before the court to get the search warrant to search is the crypto wallet or email, okay, you can say, or mobile phone also. Approach the court to seek a search warrant to search the smartphone and email. If your FSL is unable to open up that phone, you can say. If after getting such warrant, if again your accused is not cooperating, is not providing the password, then once a such warrant is issued, it is up to the original accused to provide the passport biometrics, but he is not providing again. So what IO has to do, that a notice to, that is adverse inference notice court has covered, notice to accuse indicating that in the event of accused not furnishing the third passport biometrics, an adverse inference would be drawn against the accused as regards the aspects notified in the said notice. Afterward, also he didn't disclose. Then notice to service providers like iPhone, like Samsung, in the event of the accused or any other person not providing the passcode on an application made by the prosecution, the court could direct the provider, manufacturer of the smartphone or email service provider to open up or unlock the smartphone. But again, they means they failed to get the details. They didn't comply. Okay, they didn't disclose because of privacy. Their privacy rules, you can say. Then after again, the IO has to means again file an application before the court. Permission to hack. The first time court has allowed in the event of the manufacturer and the service provider not facilitating the opening of the smartphone, email account or computer equipment, then the court and on an application being filed in that regard, permit the investigating officer to hack into the smartphone or email account. It's like you are entering into a premise and you have the search warrant to enter into that premise and you are unable to unlock the phone, means like the lock. You called a duplicate key maker and you got that premise open. So that's the same thing. So now court has clarified you can take assistance to hack. The investigating agency would be empowered to engage the services of such persons as may be required to hack into the smartphone or email account and make use of the data available therein. Relying upon the adverse inference, that's the most important part court has covered. In the event of the investigating agency is unsuccessful in hacking into the smartphone or the email account and during the course of such a procedure, if the data on the smartphone or the email account being destroyed, then the investigating of agency or prosecution would be free to rely upon the notice by which the accused was warned of adverse inference being drawn. So please go through by this judgment, very important as far as law enforcement agencies are concerned, like Viren Khanna versus State of Karnataka, very important judgment, and court has clarified some steps. Now, a very important case study as far as we have covered the issues related to investigating officer. Now, this case study, I have covered some important paragraph, taken some important paragraph of that case study, okay, where there was issue related to forensic examinations. So, Honorable Court's observation in this case study, when a party produces a documentary evidence in support of its case, two questions are required to be determined before it can be relied upon. Whether it is admissible in the evidence, if answer to question is an informative, whether the document is genuine and authentic and is without any blemish. So most important part, authenticity and source and authenticity or admissibility. So in this case, what happened? In this case, now the next question which requires the determination is whether the aforesaid memory card. So it was a sting operation of very important case in Delhi, where there was means you can say anti-corruption bureau case. Okay, so PC Act Prevention of Corruption case was initiated against two officers. So in this case, memory cards were produced before the court by the prosecution are genuine and authentic, and whether the same can be safely relied upon. So on the court part. So learned senior PP has argued that the prosecution witness 12 has given certificate under section 65B, and there is no tampering in the memory card produced by him. So there, it's a prosecution story. Expert from CFSL has also clarified that the memory card are not tampered and are genuine. And the counsel for the accused has disputed this fact and has argued that the possibility of tampering of the memory card cannot be ruled out as it is remained in unsealed condition in the custody of complainant for almost 2 years. So that's the most important part, like a chain of custody. Before it was produced and sealed before the learned Registrar General of the High Court. It was also argued that the prosecution witness 12 itself has admitted in his cross-examination. So we are talking about the cross-examination of forensic expert that he had taken the memory card, that memory card to a studio for obtaining its copies, and further he was also not aware of if the memory card used in a sting operation was new or had been used earlier. So we always advise to take the sterile memory card. So because if there is any content available in that memory card or pen drive and it has been deleted, so obviously there will be challenge regarding the hash value of this case. So what happened before the court when court observation, there's non-production of original recording device like a voice recorder. So the court strongly objected where is the original voice recorder. So in this examination, the PW12 in his examination in chief stated that the recording in the memory card were made by him with the help of DVR, which was having internal memory for recording of videos, and the same was seized by crime branch from him, and he had intimated the seizure of the same to CBI officers during investigation. Surprisingly, no attempt seems to have been made by the IO of this case, namely Tadash, Inspector and PW19 Inspector to seize the DVR used for recording the sting operation and for sending it to CFSL to ascertain whether it was in working order or not, whether it was compatible. That's the most important part, whether this voice recorder is compatible with this memory card with SD card or recording the video clippings. Hence, in the absence of original recording device, that is DVR, it cannot be said with the certainty that the video files available in the memory card and memory card were recorded directly or they had been copied from some other sources like laptop, you can say. So Learned Senior PPA has argued that in CFSL report, it has been observed that the memory cards are not being tampered and hence it would not be proper to raise doubt on the report of CFSL. But counsel for the accused has argued that a PW221 himself has stated in the cross-examination that in the absence of examining here, forensic examiner, the forensic expert cross-examinations we are talking, himself has stated in the cross-examination that in the absence of examining original recording devices that are digital video recorder, you can say audio recorder, video recorder, conclusive opinion regarding tampering or non-tampering of digital file cannot be given, and therefore his report cannot be accepted as gospel truth. He has already provided the report. He has provided his report. Now he is contradicting his report here. So, Honorable Court clarified that it is now well settled that the opinion given by the experts in a case is not binding on the court. The court has to apply its own mind, and only when the court concurs with the opinion of the experts, the same graduates in the opinion of the court. In the present case, prosecution has relied upon the 3 reports of a CFSL, the report regarding non-tampering of the memory card, and has been given by his report. He appeared in the witness box to prove his report and deposed that there was continuous flow of video and there was no stoppage, pause, means they rule out the tampering, they rule out the non-continuity. So it is continuous and there is no tampering. So, however, when he was cross-examined, by counsel for the accused, he admitted that every digital file carries its unique hash value. And although he had mentioned the hash value of hard disk sent to him, but he has not mentioned the hash value of any of the file of the memory cards examined by him. Again, there is an issue. However, no reason has been given by him for not mentioning the hash value of the digital files contained in the memory card examined by him. He further admitted that all digital files also carry their own properties, which include the time and date of creation as well as modification of these files. So this is the most important aspect where there was an issue related to handling of digital evidence by forensic examiner. So he deposed that he had looked into the properties of the files and prepared a screenshot of the same in his file. He further deposed that he had brought his file, but the screenshots were not available in his file and volunteered that the same was saved in his computer. Again, there is no satisfactory explanation forthcoming as to why copies of screenshots were not kept by him in his file or produced in the court. He also volunteered that in his report, he has mentioned the duration against memory card. Its time was actually the time of creation of digital file. So, however, a bare perusal of the report of expert would show that no date of creation or modification of files in memory cards have been mentioned in the report. Again, there is an issue of SOP. He has also admitted in this cross-examination that he cannot tell through which instrument the recording was done in the memory cards. He further admitted that in the absence of examining original recording device, conclusive opinion regarding the tampering or non-tampering of digital files cannot be given. So this is the most important thing. So again, we have to be careful. We have to confiscate the primary device source, because source is most important. Get it forensically examined, get authenticity checked. So the cross-examination thus shows that he himself has contradicted his own report regarding non-tampering of the memory cards examined by him. Hence, I don't deem it appropriate to place reliance on his report, and the same is accordingly rejected. So we have covered two things regarding issues related to investigating officers and issues related to forensic examiner also. So yes, court has clearly rejected this report. So now we are coming on a very important part, that is some cases where how to prove before the court, like hacking and unauthorized access. So somebody has unauthorizedly accessed your system, somebody has hacked your system. So what about the electronic evidence? Obviously, we have to be careful. If we came into your office, he has physically accessed your system. So we have a different type of evidence. But what about the hacking? Yes, IP address and devices and timeline. It's very important. Data theft is very important. Copying, downloading, extracting. That's the most important part. In one of the cases, what happened? There was a case of which I handled as a complaint advocate of the company. An accused joined that company for 15 days, and then after he left the job, and after 3 months, we received an email from our US client that we have assigned you a work to produce a product for us, and another company from the same city is manufacturing the same product, and they are they have sent to proposal to us to provide the product on reduced rate. So my complaint company was shocked at the time, and they searched out by way of MCA or ROC search, and they came to know that the employee who worked for us for 15 days, now he's the director of that company. So obviously they have taken away, like you can say, they have taken away our database, they have taken away our important confidential information, you can say. So how to prove? Yes, once we got the IP addresses of email ID. So because the company never changed the password of that email ID of the company, and the accused was continuously accessing that email ID from his new office. So these IP addresses were sufficient enough to prove before the court that he was remotely accessing our email ID, and his laptop was confiscated, and one by way of USB drive viewer, we got that details also that this pen drive was used to, both in like a office device also, and his laptop, and he has transferred so many files from the company system. So yes, section 43A and 43B, 66 read with 43A, 43B, unauthorized access and data theft is covered in these type of cases. So yes, get it forensically examined. So we were able to prove this type of corporate, like you can say, data theft case by way of IP addresses and remote access, and by way of that forensic examination, laptop and mobile devices and other USB devices. Then what about the computer contaminant, like ransomware attack, like somebody has sent a link or somebody has sent a drive-by download. I have sent a judgment to you. You have downloaded that judgment by way of malware. Your system got compromised. By way of email forensics, by way of laptop forensics, you can say we are able to prove that this by way of this email you got this malware into your system. By way of this malware, your system got compromised. So again, this is the most important part, that authenticity must be checked from which email ID this malware was downloaded. That's more which email this system was compromised, you can say. Then the most important part is the source code. I am handling so many cases regarding source code of IT companies. So in one of the cases, what happened, one of the gentlemen, we were working, my complaint company is working for US clients and other European clients also. So for one project, one IT professional was the project head of my complainant's company, and he was directly dealing with the foreign client. So what he did, he made a bridge with that foreign client, and he started one of the parallel company on his own, on his wife's name. And what happened, he by that being that during the time we were getting one new project from that company, but that project never came to our company, and it was diverted to by that person to her wife's company. Then afterwards, by way of very important electronic evidence, my company's IT team were able to detect some suspicious activity during, like you can say, conversations that this project has been transferred to this company. And then after we got that he has used our source code, he has transferred our source code to that company, and now he's using the same source code, or by way of alter version, you can say, the same source code for that project by way of using his wife's company. So in this case, we again lodged an FIR, again section 66, 43A and 43J, 408 IPC, and other sections, relevant sections also. But most important part, how to prove source code, because you have to provide 65B certificate of the source code before the court or before the IO. Okay. And what about the matching of the source code, whether the accused is using the same source code or he's using the altered source code. And what about the how he has stolen the source code, by way of pen drive, by way of email, by way of he has transferred directly to Google Drive also. So these are some most important aspects regarding source code theft cases in IT field. Then obscene content and porn content, child porn content. Again, if somebody has sent you the porn content, obscene content, or child porn content, it's very important, because to prove before the court, like we have discussed the case study of that prosecutor's case, mobile phone of prosecutors was not confiscated. Two mobile phone were confiscated, but there were no database, there was no data relevant to prosecutors. So the most important part is the preservation, confiscation and authentication of the primary evidence. And most important part is the interception. Now we have so many cases regarding interception, PC Act and other part of cases. Recently, earlier there was an issue before the court pertaining to voice sampling, but after Honorable Supreme Court's judgment on 2019, that voice sample accused cannot deny to give voice sample, because voice sample is like identification. It's not self-incrimination, but most important part nowadays is the review committee report. So as far as law enforcement agency officers are concerned, if you are getting interception order from the protocol, you have to comply with the 419A rules of Indian Telegraph Rules 2007. And most important part, you have to get the report of the review committee that confirms or endorses that this interception is valid or void. And most important part, the 65B certificate provided by the logger in charge. So that's the most important part, because he is the lawful controller of that voice recording. So interception is the very important part. And what about the laptop or mobile recorder devices? Okay, again, my advice is only all means to you all that always confiscate primary evidence, get it forensically examined, because we have section 76 ITI liable to be confiscation, and source and authenticity are two cardinal principles. As far as computer generated bank records are concerned, yes, get it from certified from the bank, and get section means 2A certificate from bank manager or the person who is managing these means electronic evidence details. Then CDR IPDR, it must be accompanied with 65B certificate. Include that nodal officer on your list, because court can call at any stage if there is any objection raised, like in very important case, Commander Ravind Desai case, where two nodal officers were called up by the court, and court wanted to get the clarification pertaining to the like CDR columns. Now we have 22 columns in CDRs. Earlier there were 16 or more than like 11, 12 part. So that's the most important part. Pertaining to CCTV footage, again, that's the most important evidence you have. It's a direct evidence, and honorable courts have clarified that CCTV is the direct evidence. If you have confiscated DVR hard drive, there is no requirement of 65B certificate. But if you are unable to produce the primary DVR hard drive, you have to follow the SOP. Get the forensic team before the scene of crime. They will capture. They will take the secondary evidence by way of using the primary hash value and the pre-acquisition hash value and the post-acquisition hash value. Get 65B certificate from the IT head who is handling the CCTV details system, and notify him that kindly preserve the primary evidence till the disposal of the case from honorable courts. That's the most important part. Like because CCTV is the direct evidence. Your your eyewitness can be hostile, but your CCTV is the direct evidence. Like emails, if you want to prove before the court, like emails, again, email in the A4 size paper, and also PDF file into a memory card produced before the court, and also the metadata and the message path, that is email header details. You can then you are able to prove before the court, and preservation of that email till the disposal of the case. Lastly, chat screenshots. These are vulnerables. Please, I request you all, advise you all that kindly take original mobile phone, because we have so many softwares where they can be. You have to rule out also the malicious prosecution also, because in one of the cases, what happened, we are handling in one case where it's a civil case where defendant has produced the chats before the court, and my complainant, my petitioner objected before the court that he has never sent this type of chats, because he is a 78-year-old person, and the chat includes completely the language is completely legally drafted. So obviously he denied that I have never used these type of words in my life. I cannot write these type of words. So again, there are some challenges. So we objected before the court. Now we have very important judgment, Arjun Pandit Rao. So if there is any objection raised before the court, the honorable court can seek an expert opinion from EEE lab. So again, we have to confiscate original mobile phones, and they have to send must be authenticated by forensic examination. So the most important part in these type of cases, always confiscate primary evidence, get it forensically examined. That's the most important part. And lastly, very important part, as far as a defense lawyer, if there is any type of evidence you have investigated and you have filed a charge sheet. So 207, yes, it's a statutory right of a defense. We can request before the court by way of filing 207 application that we want image copy of that memory card or CD or electronic like your hard disk or any type of electronic evidence. So court will allow in other cases, court will definitely allow, because it's a statutory right before the framing of charge. Okay, but in these type of cases where privacy issues are involved, like gang rape, obscene content, or sextortion cases, the honorable court in P. Gopal Krishnan, as Delhi Process State of Kerala, clarified that in cases involving issues such as privacy of the complainant or witness or his family or entity, the court may be justified in providing only inspection rights thereof to the accused and his lawyer or expert. The first time court has allowed the IT expert also before the court. So accused is now can produce bring his IT expert before the court, and if there is any objection raised before the court, obviously court is having the power under section 45A and 79A to get the expert opinion under section 79A from EEE labs. And recently, Honorable Supreme Court, regarding as far as law enforcement agencies are concerned, that they visited the scene of crime, they can use the application of NCRB and they can record everything. So that's the most important part. It is under pipeline, you can say. So Honorable Court stated that here all these technological innovations for use in investigation must ensure that the capturing of the crime scene through photograph, videograph, and its uploading through the app is completely tamper-free and fully encrypted. That the capturing of photograph, videography, and uploading the same through app must be contemporaneous, and to the extent possible must also come up with the GPS locations. And Honorable Court clarified that if the mobile application so developed is found to be foolproof and reliable by the experts, their report will be of great assistance. So that's the most important part. Now it's pending. The report is pending. And lastly, very important part is a thank you all. So now I am open for question and answer sessions. I hope you got some information today.
Hello. In IPC of 304B cases, if the law enforcement agency has not taken any of the digital evidences on record, what can the defense do about it?
If there is no evidence against the defense will get the acquittal. Defense will never object. Okay.
The IPC 304B is tilted against the defense because that section is worded against the defense. The onus is on the defense to prove.
No, what type of evidence you want? If there is any societal note, you can say.
No, there is no, as you were discussing during the session also, that no digital evidence, no mobile phones, nothing has been taken by the IO.
So that's the most important part. You have to confiscate the primary evidence from the accused also. Because I discussed, they confiscated 2 mobile phones, but as far as FSL report is concerned, they clarified that it contains obscene content, but not relevant to prosecutrix. So you have to prove in this case relevancy regarding to prosecutrix and must be duly proved by FSL report that there is no tampering, there is no software editing means applications installed by way of using this type of techniques. So again, because burden of proof shifts, firstly, prosecution has to prove before the court beyond doubt. That's the basic criminal justice system. So if there is any evidence with the defense, obviously defense can produce before the court, court has power. Accused can also provide evidence before the court at the stage. Sir, I am having this evidence. Court has power to seek an expert opinion from forensic labs, 79A labs. Court can seek an expert opinion if there is any issues. Obviously, complainant will raise objection at the stage regarding these evidence. So court is independent. Court can seek an expert opinion. But if there is no evidence, obviously, defense will get the benefit.
Good morning, sir. This is Jefframaya from Andhra Pradesh Police. I'm very happy to see you. I'm very happy to see you again, sir. Earlier, I met in CDTI, sir. I'm very thankful for your class. Valuable information. I'm very happy to see you again and again. And I'm looking forward to more sessions from you, sir.
Thank you. Thank you. Thank you.
Yes, sir.
सर नमस्कार भागीरथ सर मेरे क्वेश्चन है कि जो फेसबुक है व्हाट्सएप है जिसे सूचना देती है उसमें 65B का प्रमाण पत्र नहीं आता तो उसको कोर्ट में एग्जिबिट कौन करता है। सेकंड है कि सर 65B सीसीटीवी फुटेज के अंदर और दूसरे जैसे स्क्रीनशॉट किया गया मोबाइल का व्हाट्सएप का उसका 65B दे देता है। 65B के एग्जामिनेशन के समय क्या वो मोबाइल और वहाँ पेश करना होता है क्या कि कोर्ट के अंदर ट्रायल कोर्ट के अंदर इसमें किसकी रेस्पॉन्सिबिलिटी थी? अगर वो मोबाइल बेच दिया गया है तो फिर उसका क्या एविडेंस पे क्या इफेक्ट आता है?
आपके सेकंड क्वेश्चन का तो आंसर मैंने वो केस स्टडी आपसे डिस्कस किया जिसका प्रोसिक्यूटर्स का मोबाइल फोन नहीं सीज किया गया, उसका लैपटॉप सीज नहीं किया गया, मोबाइल तो उसने स्क्रैप डीलर को दे दिया। आयो साहब 3 महीने बाद जा रहे हैं स्क्रैप डीलर के पास जाके कि मेरे को मोबाइल दो। अब स्क्रैप डीलर के पास मोबाइल कहाँ होगा? तो गलती किसकी हुई? आयो की, कि ही नेवर कॉन्फिस्केटेड प्राइमरी एविडेंस फ्रॉम प्रोसिक्यूटर्स। लैपटॉप भी सीज नहीं किया, वो भी हार्ड डिस्क खराब हो गई। तो दो चीजें इंपॉर्टेंट है। एज फार एज फर्स्ट आंसर इज कंसर्न, उसमें ये इशू है कि जो भी नोडल एजेंसी, जो भी आप एनआईसी का, जैसे लाइक आप आईओ हैं, आपके पास एनआईसी का ईमेल आईडी है, यू आर रिसीविंग डिटेल्स फ्रॉम इंटरमीडियरी फेसबुक। फेसबुक अभी तक आपको कोई नोडल ऑफिसर कोई भी फेसबुक का 65 भी नहीं दे रहा है, बट यू हैव रिसीव्ड एज एन एड्रेसी, बिकॉज आपके पास ईमेल आया एनआईसी के मेल आईडी पे, सो यू आर एबल टू प्रोवाइड 65B सर्टिफिकेट बिकॉज यू हैव रिसीव्ड एज एन एड्रेसी, राइट सर। जैसे मैंने आपको ईमेल किया तो आई एम द ओरिजिनेटर, यू आर द एड्रेसी। जैसे ईमेल को आप प्रूव कर रहे हैं कोर्ट ऑफ लॉ में, आपको वो प्रूव करना है कोर्ट ऑफ लॉ में कि आई हैव रिसीव्ड दिस डिटेल्स फ्रॉम दिस इंटरमीडियरी इन माय इनबॉक्स, इट इज प्रिजर्व्ड, आई एम द लॉफुल कंट्रोलर, द रिप्रोडक्शन इज द सेम which I have received from the originator and this is preserved for subsequent accessibility। कोर्ट के सामने अगर ओपन कराया जा सकता है तो ओपन, कोई चैलेंज हुआ है साहब करा दीजिए ईमेल फोरेंसिक्स, ये सब चेक कर लीजिए, इसमें कोई इशू तो नहीं है, किसी ने स्पूफ तो नहीं किया। इट माइट बी पॉसिबल, मैंने भेज दिया आपको कि चलो जी फेसबुक से डिटेल आ गई। सो ये मैसेज पाथ बहुत इंपॉर्टेंट है। हेडर डिटेल्स आपके पास फेसबुक से भी आया है, हेडर डिटेल्स दीजिए साथ में कि सर ये पूरा मैसेज पाथ है, ये मैं साथ में एंडोर्स कर रहा हूँ, योर केस विल बी स्ट्रांग।
थैंक यू सर।
Anji, any other questions? So an excellent session by Nishit ji. Thank you so much Nishit ji. बहुत मतलब सुन के मजा आया, काफी कुछ सीखने को मिला और lot of good things to learn, good things to understand. छोटी-छोटी जो aspects हैं which are missed by a lot of people, जो आप मतलब सामने लेके आए, ये हम सबके लिए बहुत useful हैं, कामगार हैं, and we are thankful to you for that. चंद्रकांत जी है यहाँ पर, चंद्रकांत जी को एक का सवाल है, so let's add him.
Good morning, sir. Can you?
Yes, we can hear you and see you.
Yeah. Can you hear me?
Yes.
My question is simple questions regarding the Facebook or any WhatsApp messages. The vulgar WhatsApp messages and any pornographic WhatsApp messages or any messages, such a messages has been sent in group by some another person, and that message has been forwarded to another person, and that is why criminal right happened in the area. So what we have done, that time the forensic science and other facility was not proper in this way. What we have done, whatever the message has been stored in his data, we made video recording of that in presence of two authorized panchas, and we had been produced that court of law, and the court of law has accepted that whatever the message has been sent by the offender, the police was seized that mobile and police has taken the videography during the Panchanama, and we show that this is the message. Is it okay?
So what about the authenticity of that mobile phone जिसमें वो content आया था, जिसमें से means you like videographed, right? What about the authenticity of that content?
Sir, basically he has received a message from another person.
I understand. Okay, but have you sent that mobile phone to forensic analysis?
Yes, forensic analysis we have sent, but the forensic science laboratory was not able to capture the data. Meanwhile, the data has been deleted by some by mistake or some these things.
By mistake, by forensic examiner or by way of
forensic examiner, for a forensic examiner.
That's an issue. That benefit of doubt. No. That's an issue. Even Samir can answer, because I can use photo editing shops. I can make any type of content, right? Like by way of using any type of alteration, I can prove before the court. Okay, in this case, you can prove by way of confiscating the accused mobile phone. Have you confiscated accused mobile phone?
Yeah, we have confiscated accused mobile phone. We seized the accused mobile phone under the recovery of 427 Indian Evidence Act.
Whether it has been forensically examined, whether you found that content which has been sent by the accused by way of using that phone, whether this content which you recorded from that phone where you don't have data, but now you have the accused mobile phone, whether this mobile phone is having the data which has been sent by accused to the victim, it has been corroborated by forensic evidence examiner or not?
One thing, sir. Whatever the message has been sent by the offender's mobile, we seize the mobile in PCR of the accused under 27 Act.
Okay.
Thereafter, in presence of two panchas, we made a panchanama and done a videography. We asked that victim to show what message you have sent, and we recorded under the video, and we also took a photograph of that particular data. Thereafter, we sent a charge sheet, and before that, we sent that mobile to FSL, but FSL has denied to give any evidence because the data was, meanwhile, maybe there is a system, WhatsApp message can be deleted within 13 days, or any message can automatically they deleted 30 in, अब जैसा वैसा होता है कि 30 दिन के अंदर अपने WhatsApp मैसेज डिलीट हो जाते हैं. The data was deleted in meanwhile, and forensic FSL wale was not given in proper evidence. But court has accepted, the police has done this thing, and in presence of two panchas, it is valid. In our case, I am talking about the case in 2014.
14.
Not, thank you.
I don't know. Defense has not objected. Why the defense has not objected?
Yeah, defense has objected lot of.
Whether they have filed an appeal, where they have filed an appeal before the court.
No file.
So that's why that's important.
But we have seen our integrity was very pure.
Yes, you have done bona fidely what you can do. Okay, आप जो कर सकते हैं वो आपने किया उस वक्त, वो बात सही है. But the most important part, defense can raise an objection before the court. What about the authenticity? Because Arjun Pandit Rao court clarified in para 17, if there is a objection by before the court, what about the authenticity of primary evidence? कहाँ से भाई आप किसका करेंगे? आपने तो कोई suppose मेरे पास एक ये laptop, I am using this laptop. Okay, I am having one memory card. मैंने इस मेमोरी कार्ड को इस लैपटॉप पर इंसर्ट किया. आई मेड इन मॉर्फ कंटेंट, ऑप्शन कंटेंट बना के एक लड़की का लड़के का मिला मिलू के हस्बैंड का बना के और बना दिया एक मॉर्फ कंटेंट. देन आई इंसर्टेड दिस मेमोरी कार्ड इनटू मोबाइल फोन, राइट सर. और मैं आईओ के पास आ गया कि देखिए सर मुझे ये कंटेंट उसने मुझे भेजा. आपने क्या किया? आपने वीडियोग्राफी कर लिया, रिकॉर्ड कर लिया, या मुझसे स्क्रीनशॉट ले लिया, 65B ले लिया और आपने केस फाइल कर दिया, राइट सर. और आपने उसका मोबाइल सीज कर लिया, उसको 204 में बंद कर दिया कि साहब आपने डाटा डिलीट किया, जबकि उसने कभी भेजा ही नहीं है, बनाया तो मैंने. सो विदाउट द सोर्स एंड विदाउट द ऑथेंटिसिटी ऑफ दिस कंटेंट, दिस मेमोरी कार्ड भी नहीं लिया, क्योंकि कंपैटिबिलिटी अभी मैं जो डिस्कस कर रहा था पीसी एक्ट का, मेमोरी कार्ड विदाउट द वॉइस रिकॉर्डर, कोर्ट ने ऑब्जेक्ट कर दिया. इवन एफएसएल ने ही अपना बता दिया कि नो वी कैन नॉट असर्टेन दैट ये कंपैटिबिलिटी इस वॉइस रिकॉर्डर की इस मेमोरी कार्ड से है. सो देयर आर सो मेनी चैलेंजेस एज फार एज इलेक्ट्रॉनिक एविडेंस कंसर्न. तो मेरी आप सबसे रिक्वेस्ट यही है, यही ओपिनियन है, seize the primary, get it forensically examined. That's the most important fundamental. Secondary evidence में मत जाइए. Secondary वो है servers हैं. You cannot bring server before the court. Then you can get multiple airport पे कोई CCTV लग रहा है. You are not able to get the DVR hard drive. Follow the FSL, follow the SOP, get it for forensic team को बुलाइए. Pre-acquisition hash value, post-acquisition hash value लीजिए, 65B सर्टिफिकेट लीजिए, प्राइमरी प्रिजर्वेशन नोटिस दीजिए. योर केस इज स्ट्रॉन्ग. बोनाफाइडली आईओ को कोई टच नहीं करेगा, बिकॉज आईओ ने सब कुछ कर लिया. अब एक केस बड़ा इंपॉर्टेंट मैं आपसे डिस्कस करता हूँ इन ए फनी मोड. व्हाट हैपेंड इन ए टोल, देयर वाज एन इशू. एक टोल था जहाँ एक झगड़ा हुआ, रिकॉर्डिंग हुई टोल पे, सीसीटीवी लगा हुआ था. आईओ पहुंचे, वहां से सीसीटीवी में रिकॉर्डिंग कहाँ पे लिया उन्होंने? पेन ड्राइव में. पेन ड्राइव चलता हुआ, जैसे हमने डिस्कस किया स्टेराइल पेन ड्राइव. व्हाई वी आर यूजिंग द वर्ड स्टेराइल पेन ड्राइव, कि उसके अंदर कोई कंटेंट ना तो गया ना डिलीट हुआ. वो स्टेराइल पेन ड्राइव नहीं था, सिंपल चलता हुआ. क्या किसी से बोले आपके पास है? हाँ पेन ड्राइव मेरे पास है. तो उन्हीं टीम में से पेन ड्राइव लिया, पेन ड्राइव से वो सीसीटीवी फुटेज लिया. वो सीसीटीवी फुटेज आईओ साहब ने अपने लैपटॉप में लगाया, देखा अच्छा झगड़ा हुआ है. उसके बाद सीओ ने देखा, सीओ के बाद आईजी साहब ने, सीनियर अधिकारियों ने देखा. जस्ट फॉर एक केस के हिसाब से आपसे डिस्कस कर रहा हूँ. जब वो एफएसएल के पास पहुंचा पेन ड्राइव, एफएसएल रेज हैंड्स कि भाई ये नहीं चल रहा. समीर सर ने हाथ खड़े कर दी कि भैया नहीं चल सकता, जैसे आपका वाला नहीं चला, एफएसएल से करप्ट हो गया, खत्म. अब 15 डेज के बाद आयो कहाँ भागे? टोल पे, कि भाई वो डाटा होगा उसके अंदर. उसने कहा भाई बहुत जल्दी आए आप, तो वो तो क्या हो गया? ओवरराइट. अब देयर इज नो एवर. सो यहाँ क्या हुआ? यहाँ दोनों गलतियां हुई. या तो प्राइमरी डीवीआर हार्ड ड्राइव लेते तो केस स्ट्रॉन्ग था, या सेकेंडरी लेने का एसओपी फॉलो करते हैं कि भाई सेकेंडरी में ले रहा हूँ, प्रोटोकॉल मेंटेन करते हुए ले रहा हूँ, मैंने हैश वैल्यू लिया, इंटीग्रिटी मेंटेन्ड है, उसके बाद मैंने पेन ड्राइव में लिया, मेमोरी कार्ड में लिया, 65 भी सर्टिफिकेट आईटी हेड या एडमिनिस्ट्रेशन जो भी है मैनेजमेंट कर रहा है उससे लिया, और उनको प्रिजर्वेशन नोटिस भी दे दिया, और उसको मैंने एफएसएल के लिए भेज दिया। रूल आउट द टेम्परिंग, 3 क्वेश्चन पूछने हैं सीधा, रूल आउट द टेम्परिंग, कॉन्टिन्यूटी, मैचिंग, ये बंदा ये लोग मैच कर रहे नहीं कर रहे, बस तो सिंपल ही बात है। तो ये बड़े चैलेंजेस हैं आज की डेट में, बिकॉज डिफेंस स्ट्रांग नहीं है, इसलिए केस आगे चल रहे हैं। अगर डिफेंस स्ट्रांग है तो हर चीज पे आप भी, चंद्रकांत जी भी मुस्कुरा रहे हैं, समझ रहे हैं बात को कि यस ये दिस इज द इशू, बिकॉज डिफेंस इज नॉट स्ट्रांग। डिफेंस की क्लासेस नहीं हो रही आज, कोई भी डिफेंस का लॉयर नहीं है, हम सब लॉ इन्फोर्समेंट एजेंसीज के ऑफिसर्स हैं, राइट। वी आल्सो टीच द लॉ इन्फोर्समेंट एजेंसी मैक्सिमम लॉयर्स को। तो मैं अब जा रहा हूँ उदयपुर बार एसोसिएशन को सेशन लेने, सो दैट्स द मोस्ट इंपॉर्टेंट पार्ट। बट एज फार एज लॉ इज कंसर्न, जुडिशियल अप्रोच इज स्ट्रांग, यू नो, आपको इन्वेस्टिगेशन करना, यू हैव टू बी केयरफुल, collection, identification, मैंने आपसे डिस्कस किया, ऑनरेबल कोर्ट strongly objected and he instructed DGP of that state kindly lodge FIR against that investigating officer who was unable to identify and collect the CCTV footage. So ये एक बड़ा important challenge है। कहते यही कहा जाता है कि कुछ भी मिल जाए, कहते हैं ना कि अगर होल्डर भी मिल गया और कहीं कोई मतलब सॉकेट भी लग रहा है वो भी लिया हो, कोर्ट विल नेवर आस्क भाई ये क्यों लिया है, कोर्ट विल आस्क ये क्यों नहीं लाए, प्राइमरी क्यों नहीं लाए। When primary can be bring before the court, confiscate primary, जहां आप reasonable डाल सकते हैं कि सर we were unable to confiscate primary, we have, तो आपको SOP फॉलो करना है सेकेंडरी एविडेंस का लेने का, 65B का, हैश वैल्यू का, प्रिजर्वेशन ऑफ प्राइमरी, बिकॉज सेक्शन 4 सेक्शन 7 IT Act is very important and most important section 3 authentication of electronic record, that is hash value.
एक मिनट सर, एक मिनट बता दो।
Yes please please.
एक सिंपल मर्डर केस है, सिंपल, और मर्डर केस के कुछ वेपन्स, आर्म्स एंड वेपन्स एक नदी में डाला हुआ है, और हमने आरोपी को अरेस्ट किया, उसका PCR लिया, और रिमांड के बाद उसको हम रिकवरी करने के लिए गए। उन्होंने क्या बोला कि आप पानी में से उतर के वो निकालना है। तो जब ये पानी में उतरा है तो आई मेड अ वीडियो शूटिंग बाय माय मोबाइल फोन एंड माय कॉप, जिसको स्विमिंग करने को आता है, इन प्रेजेंस ऑफ 2 पंचास। आई एम टेलिंग यू, एज पर द कोर्ट वी आर डूइंग आवर सीजर इन प्रेजेंस ऑफ 2 पंचास 127। और वीडियो शूटिंग मैंने किया है मेरे मोबाइल से, ऑथेंटिसिटी मैं अभी कहां से लेकर जाऊंगा, लेकिन आई एम IO, माय इंटीग्रिटी एंड माय दिस थिंग इज प्योर, I had to submit an evidence। तो वीडियो शूटिंग किया है, और वो हथियार निकाल के दे रहा है और ये बाकी निकाल के दे रहा है, उसका वीडियो शूटिंग किया। इसका मैंने एक छोटा सा डिस्क बनाया और डिस्क कोर्ट में सबमिट किया कि दिस इज हैपन। वो कोर्ट ने एक्सेप्ट कर लिया।
हाँ बिल्कुल। और आपने 65 भी दिया क्या?
मेरा खुद का 65 सर्टिफिकेट दिया।
अब
यस, आई एम IO, but I can submit my 65B।
अब मैं आता हूँ डिफेंस की स्ट्रेटजी, व्हाट डिफेंस कैन डू।
डिफेंस ऑब्जेक्टेड इट। डिफेंस ऑब्जेक्ट किया, बोला इट इज नॉट वैलिड।
ओके,
तो मैंने कोर्ट को बोला सर लेट द डिफेंस ऑब्जेक्ट, लेकिन इट इज हैपेंड इन प्रेजेंस ऑफ 2 पंचास। यू कैन सी इन वीडियो पंचास आर प्रेजेंट, देन वेपन्स आर गोइंग टू बी taken by river in presence of 2। either you take it as evidence or not take it, but it is my purity, I have done it।
इसका आंसर ये है, और मैं आपको ये रिक्वेस्ट भी करूंगा, हमेशा ध्यान रखिएगा, नेवर यूज योर पर्सनल मोबाइल फोन्स, ऑलवेज यूज ऑडियो वीडियो रिकॉर्डर। एक ऑडियो वीडियो रिकॉर्डर रखिए, और स्टाइल मेमोरी कार्ड, 5 मेमोरी कार्ड हमेशा रखिए अपने पास, नए ओरिजिनल, राइट। और जैसे कोई इन्वेस्टिगेशन हुआ, ये नया मेमोरी कार्ड लगाया इसके अंदर पंचों के सामने कि सर मैं नया मेमोरी कार्ड इस ऑडियो वीडियो रिकॉर्डर में लगा रहा हूँ, रिकॉर्ड करिए, मेमोरी कार्ड इज अ प्राइमरी एविडेंस, सीधा दीजिए कोर्ट में कि साहब ये आपका हो गया। नेवर यूज योर, कितने केसेस में आपका मोबाइल जब्त होगा और कहीं बच्चे ने डिलीट कर दिया शाम को घर जाके, आपका वीडियो गेम खेल रहा है उसी मोबाइल से, उसने ओरिजिनल एविडेंस उड़ा दिया, अब आप भेजिए FSL की साहब रिकवर करो प्राइमरी। और ये क्या होगा, डिफेंस क्या करेगा इस केस में, वो 5 साल 6 साल वेट करेगा। 5 साल में आपने iPhone 7s की जगह iPhone 13 ले लिया, वो 7 तो गया एक्सचेंज ऑफर में, आपसे कोर्ट में ऑब्जेक्शन किसने रेज किया, ऑब्जेक्शन किया डिफेंस ने। पैरा 17, ध्यान रखिएगा, पैरा 17 अर्जुन पंडित राव का सुप्रीम कोर्ट का जजमेंट में क्लैरिफाई है, सेकेंडरी एविडेंस 65B के साथ दिया। अगर डिफेंस ने ऑब्जेक्शन रेज कर दिया तो ऑनरेबल कोर्ट क्या मांगेगी, एक्सपर्ट ओपिनियन। अब एक्सपर्ट ओपिनियन लें किससे, किसका, प्राइमरी तो है नहीं, समझे आप
Okay.
बात को। तो
Yes, sir.
नेवर यूज आपका केस, मैं अगेन कह रहा हूँ, डिफेंस स्ट्रांग नहीं है, आपका काम चल रहा है बिकॉज डिफेंस को नॉलेज नहीं है, डिफेंस स्ट्रांग नहीं है। लेकिन ध्यान रखिएगा, आईओएस ध्यान रखें, नेवर यूज योर फोन ऑडियो वीडियो करते हैं, वो अलग बात है, बट मेमोरी कार्ड नया लीजिए, लगाइए कंपेटेबिलिटी, क्योंकि ओरिजिनल ऑडियो वीडियो रिकॉर्डर है आपके मोबाइल पे बेस्ट है, क्योंकि प्राइवेसी भी इशूज हैं। वो मोबाइल में हो सकता है कोई ऐसा कंटेंट है, आप ऐसा कोई कंटेंट रिकॉर्ड भी नहीं कर सकते जहां प्राइवेसी इशू आ जाए। तो ये थोड़ा सा इशू है। ऑडियो वीडियो रिकॉर्डर रखिए, सीन ऑफ क्राइम के लिए रखिए, और उसमें सीधा मेमोरी कार्ड डालिए। इट्स ए केस प्रॉपर्टी। इट्स अ गुड
Thank you,
क्वेश्चन,
thank you.
वेरी गुड क्वेश्चन। थैंक यू,
Thank you.
थैंक यू।
बहुत बढ़िया strategy. Thank you. It is basically, I think, very important for officers, IOs, as well as FSLs and all who have to appear in court to understand all these finer aspects, because a lot of cases they get thrown out for the simple reason or some procedural problem or some minor issue which has been overlooked and which the defense takes and unravels the whole case, and then the judge is also perforce has to say कि भाई इसको बरी कर दिया जाए because it is not admissible or acceptable.
Very well explained, Nishit sir. Very well explained. Very in depth.
Excellent. So thank you very much. And I think you have kept the audience spellbound. Thank you. Thanks very much. We meet again next Friday, next Forensic Friday.